Hi, I'm Kelly Caplan with Lawyers Weekly. Joining me for today's Sidebar conference is WMU Cooley Law Professor David Tarrien. Thanks for taking the time today, Professor.
Pleasure to be here.
All right. Professor Tarrien is an expert in legal issues surrounding the Americans with Disabilities Act and HIPAA. So as the nation works to help slow the spread of COVID-19 coronavirus, states are now grappling with the issue of whether to mandate wearing masks in light of the protections available under the ADA and HIPAA. So Professor Tarrien, what legal concerns exist for those who want to enforce the use of masks and for those who choose not to wear them?
Okay, so the ADA provides a shield for people with disabilities and guarantees access to public space with reasonable accommodation. So anybody who operates a public space, any business, for instance, that allows access to the public, has to have that in the back of their heads when they deny access to somebody who claims a disability. So if a person claims that they have a disability, for instance, so they cannot wear a mask, what the business owner has to take into account is that they can't really challenge the person on whether they have a disability or not. Okay, because that is inappropriate. But they have to allow reasonable accommodation, which in normal times, not wearing a mask would be able to be accommodated. However, these are extraordinary times, and reasonable accommodation has to be given, the emphasis on reasonable. There is always a defense for businesses. Basically, if there is a direct threat created by the accommodation request to other people who use the business or to the person with the disability themselves, then that is a sound basis to deny entry. And so not wearing a mask with the way that the COVID-19 is transmitted, there can be a pretty compelling case made, particularly in times where there are spikes, that due to the direct threat that presents to everyone, access can be denied. So what business owners should do, and if I was advising somebody as an attorney who was asking this question, who owned a business, is to just say, I cannot provide access to you right now. Now, they may go away and they may try to find remedy for that at law, but the case is pretty compelling right now for the business owner that this is a direct threat.
So I've seen all over the internet, and people are claiming to be able to use those cards that have been printed up saying, I have a medical condition, I'm exempt from wearing a mask. What happens if you're presented with one of those?
Well, you can do exactly the same thing. You can say, that's fine, but I'm still not granting you access because it creates a threat to the other people who are in the store.
Okay.
And so those the cards themselves have no legal effect. Even a doctor's notice, it's evidence that they may have a disability, but again, it's the accommodation that's the issue, not necessarily whether they have a disability or not. And if the accommodation cannot be granted safely, the person claiming the rights under the ADA is kind of out of luck. And incidentally, if people are using the protections granted by the ADA as a sword rather than a shield, if they're using it inappropriately or claiming protection when they do not have a disability, and that is found out, there are criminal and civil consequences for that, for the person making the claim.
Okay. So mask requirements vary wildly from state to state across the country.
Yeah.
And there's reports now of police agencies who won't enforce these restrictions or the rules. Governors are rescinding, mayoral rights and saying, no, we're not going to mandate that. So with all this confusion, what are the key points that attorneys should be aware of if they get potential calls from potential clients, either individuals or businesses?
Right. Well, anybody who has executive authority, whether it's a governor or a mayor or a president, uh, has the ability to put these types of orders out there, particularly in times of emergency. And the first important thing to know is that such orders do have the force and effect of law for the people that they're directed to. And that will be the case until or unless a legislature or a court says otherwise. Okay, so when these go into effect, they have the force and effect of law and should be followed. Now, the folks who have the responsibility for enforcing this are also essentially within the executive branch of government, and they have prosecutorial discretion. So for instance, the sheriffs who are refusing to enforce these, they can do that just the same way that they can make a decision in the field to take various types of evidence into account when deciding whether to bring a criminal charge or not. It's a little unusual that it is expressed as a general overall policy, but it's probably within their legal right to do so.
Okay, so none of us has a crystal ball. None of us can predict the future. But what do you foresee happening, in the coming months in terms of potential suits or legislation?
Yeah. Well, it really does sort of depend on facts on the ground. If the pandemic doesn't go away and cases spike and deaths spike, it's likely that there will be more restrictions put into place rather than fewer. And once again, those restrictions have the force and effect of law. And in times of emergency, they're given a great deal of deference by the courts. So because the police powers are to protect the health, safety, and welfare of the citizens of any jurisdiction. And so as long as the orders are designed to do that, then they'll probably be seen as legitimate. Now, if the cases start to wane, if the pandemic starts to slow down to an extent that that we're comfortable with having a more public life outside of the walls of our own homes, then those types of restrictions, if they remain in place too long, they'll probably be challenged, and there's a more compelling case to be made at that point that they are inappropriate. So, and that's true even at the level of people going to a grocery store, for instance, and trying to gain access. If they're denied in a time when cases are down, or in a community where there are very few cases, being denied access, the direct threat claim might not be as compelling, and that would be paid attention to by the courts as well.
Okay, so uncertain times, unprecedented times, everybody's trying to figure out what's going to happen next. So I guess, just to kind of wrap this up, what are some key takeaways that attorneys should be aware of with ADA and with HIPAA requirements? Any minefields?
Well, I'll go to that. Yeah, well, and actually, it's more clear than at first blush. First of all, HIPAA in this realm, HIPAA is designed to prevent medical service providers from sharing private information with other folks. So HIPAA, there's a misnomer out there that it applies in these types of situations, and it does not, because it doesn't involve medical personnel sharing files. This is just a store owner asking a question. So HIPAA doesn't apply at all. And in terms of the ADA, again, because the standard of a reasonable accommodation is pretty clear, and the scope is made even more clear by the defense of direct threat. That's really pretty straightforward as well. So anybody who comes into your office saying that they've been denied service because they couldn't wear a mask, I would probably not take that as a case to move forward on, unless, as I mentioned before, there were very few cases in the area that we were in. Because among other things, if you have a disability to the extent that putting a mask on is going to inhibit that, you're probably in a number of risk categories, and it's not your best move to go into these public spaces anyway. The other part of that, I guess, is that you can wear a mask successfully with minor respiratory issues. Both my wife and my daughter have asthma, for instance, and they wear masks just fine. So the disabilities that would be more compelling would probably be things that are pulmonary respiratory illness that is in advanced stages, emphysema, things like that, where you have another breathing apparatus, so you physically can't wear a mask. Possibly things that affect mobility in your hands, because if you can't tie a mask, that could create a more compelling argument for why you can't wear the mask. Okay, but again, really the issue is about access. It's not even about whether the disability is valid or not.
Right. Professor Tarrien with WMU Cooley Law School, expert in ADA and HIPAA. Thanks so much for taking the time today. I really appreciate it.
Thank you for having me.
Okay, take care.
You too.